Hey everybody, it's Kathy. Hope that you're all doing well on this Mother's Day. I know that this is a tough day to have alive because it is Mother's Day in the United States. And I wanted to send out my wishes to all of the mothers across the country. I hope that you're having a spectacular day celebrating your children. I certainly am so pleased and delighted to have had the wonderful experience of having two beautiful children, and they both remembered me today. And it's a great day, I think, in the American calendar that we celebrate mothers today. So again, if you're watching on replay, I know a lot of my followers, especially from the podcast, are overseas. It's the middle of the night for them. I've gotten a couple of questions from them that I'm going to be addressing before the end of today's presentation. And without further ado, let's get started. The case is Idaho versus Kohberger. It is a capital case that is currently pending in Ada County, Idaho. The principal parties involved are the state of Idaho. That is who is the plaintiff in the case. The people of the state of Idaho have brought this action against Brian C. Kohberger. He is the defendant. The attorneys that are representing the state of Idaho, there's several of them, but the chief attorney prosecuting the case is William Thompson. He is the chief prosecutor. He was elected back in 1992 in Latah County. The chief defense counsel for Mr. Kohberger is Ann C. Taylor. She was appointed back in December of 2022 at the time of Mr. Kohberger's arrest. Just by way of background, this case is probably one of the saddest cases that you will ever learn about. It involves, in a moment, the taking of four precious young people who were in a rental home just steps away from the University of Idaho, where they were all four attending classes in order to pursue what is the American dream, to get an education, to further in life, and to give back to your community, to your country. In what we've been told, on November 13th, 2022, their young lives were taken in an extremely brutal way. And so we always must remember Madison, Kaylee, Xana, and Ethan. Our podcast, which I established to go over, it's called Idaho versus Kohberger. Before I established this YouTube channel a year before I did, was intended to go over the court proceedings in 5 minutes or less. It appears on Spotify, it's on Apple, it's on Amazon, it's on a number of platforms, but I think the best platform is that it does populate here onto YouTube, and there's a search engine. So if you want to look at something such as the non-dissemination order, change of venue, indictment, any area that you might be interested, because the docket is extremely long. It's unsearchable. It is not very user-friendly, and sometimes, quite frankly, the titles of the document do not let you know what it's all about. You just plug in your search term. It'll pull up one of these 650 episodes, 5 minutes or less. It goes over a document or something on the case summary page, which I constantly invite you and recommend that you look at the court documents, look at the case summary page. It will tell you what's been going on in the case from the beginning. The beginning being December 29th, 2022, after the hunt for the perpetrators of the catastrophic events at 1122 King Road. 4 documents were filed, number 1 being the affidavit of probable cause. This was an 18-page document filed under penalty of perjury by Detective Brett Payne of the Moscow Latah County Police Department. Detective Payne is considered the lead detective in the case. He will be at trial. There has been an order entered by Judge Stephen J. Hippler that 4 parties, 2 from the state side, 2 from the defense side, will be in the courtroom during the entire trial, irrespective of if they're going to be testifying or not. This was based on a stipulation between the state and the defense, Detective Brett Payne being one of those 4 people. Detective Payne asked for a warrant for Mr. Kohberger's arrest after going into a recitation of the very tragic events at 11:22, some of the details of the investigation. Moscow Police Department's the lead agency. This is their jurisdiction. They invited in the Idaho State Police and the feds to assist them with the investigation. There is a lot of talk about 2 items that I believe led, in my opinion, directly to Mr. Kohberger's arrest. Number 1, the movements of the so-called 8458 phone, which is believed to be Mr. Kohberger's cell phone, and the actions regarding suspect vehicle 1. Also, on December 29th, 2022, there was a complaint that was sworn out by Mr. Thompson, charging Mr. Kohberger with 5 counts, 5 felonies, first-degree burglary, and then first-degree unalivings of the 4 students. The third item that was filed on the document the very first day the case was opened is the order finding probable cause that was signed by Magistrate Judge Megan E. Marshall. She was the first jurist in the case of the 3 that have presided over this proceeding. And then finally, a warrant seeking Mr. Kohberger's arrest. Now, Mr. Kohberger was not in Idaho. He was not in Pullman, Washington, where he had been for approximately 3 to 4 months. He was a graduate student at the university, at Washington State University in Pullman, where he had an apartment and where he was a teaching assistant. This was between the Christmas, New Year's holidays, and he was across the country in Pennsylvania, specifically in Albrightsville, Monroe County, Pennsylvania. And because the 50 states, the way that we operate here in the United States, we have the federal government, and then we have the 50 states that operate as their own mini governments as well. Idaho could not go into Pennsylvania, Commonwealth of Pennsylvania, to effectuate Mr. Kohberger's arrest. Therefore, they sought help from local authorities who had jurisdiction in Pennsylvania, and Mr. Kohberger was indeed arrested on the 30th of December, 2022. At that time, if you look at documents, which I encourage you to do, Commonwealth of Pennsylvania versus Kohberger, you're going to see basically 2 sets of information. You're going to find the affidavit of probable cause that was sworn out in Pennsylvania seeking Mr. Kohberger's arrest. And you're going to see inventories and an explanation post-arrest as to what's happened. I invite you to take a look at the inventories that were returned regarding what happened, what was taken from the property and from Mr. Kohberger's person. Of those, on line 13, on one of the pages, you're going to see a cellular phone. That is believed to be the 8458 phone. It was seized at that time being December 30th, 2022. There was then an extradition hearing. Mr. Kohberger did not fight extradition. He agreed to return voluntarily to Idaho, and he did. But before he did, state of Idaho and the defense felt that it was prudent to seek a non-dissemination, aka a gag order. They stipulated to, meaning they agreed to, going to the first jurist, Judge Marshall, and saying that there should be a non-dissemination order. And you can find it on the docket. It's one of the first items on the docket, stated January 3rd, 2023. This is approximately 4 days after Mr. Kohberger's arrest. And you will see the reason given for the non-dissemination order: to keep matters under seal, to have no one to be able to go out and give interviews, as you see in other high-profile cases. You'll see in other high-profile cases, prosecutor, the defense coming out once in a while and giving an update to apprise the public as to how the case is going. You've never seen anyone from the state or anyone from the defense ever doing so because of the non-dissemination order that was entered January 3rd, 2022. And the reason it was given above the signature line on the stipulation was to protect the integrity of the case at trial, to make sure that evidence wasn't out there so that Mr. Kohberger was not tried in the media, was not tried in the public, that his due process privileges, his Fifth Amendment, his Sixth Amendment privileges, the state's right to be able to present their case also would be protected. Now, there have been 2 attempts to set aside that non-dissemination order by the media itself. And I must add here that there were a couple of amendments to that non-dissemination order. One was done by Judge Marshall in January of 2023. A second was done by Judge John Judge, who was the second jurist in the case, both of which occurred in Latah County. The Media Coalition, which is a group of 20 members of the media, went to the Idaho Supreme Court first to try to get that non-dissemination order set aside. And it is entitled, it's in the Supreme Court of Idaho. Here's the document. You can find it online. It's called In Re Petition for Writ of Mandamus or Writ of Prohibition. What this means is they wanted the state of Idaho to reach down into Latah County and stop the continuation of the non-dissemination order. That is what a writ of prohibition or mandamus means. So it's styled as the Associated Press, and then there's 19 other members of the press, versus Second Judicial District of the State of Idaho, County of Latah, Honorable Megan E. Marshall, Magistrate Judge, and then also, because this involved other parties, and Brian C. Kohberger and the State of Idaho prosecutor. If you look at that document, you're going to see a big fat denied on page 2. What the Idaho Supreme Court found is that while the Media Coalition did have standing to go in and to challenge under the First Amendment if this non-dissemination order, amended non-dissemination order, was appropriate or not, should be set aside, they said, you don't come to us first. You go to the district court first. So then there was an attempt in Latah County to set aside the non-dissemination order. Judge John Judge denied it. That non-dissemination order has been in effect in one way or the other since Latah County days. No one has ever moved to set it aside since Judge Judge rendered his ruling telling the Associated Press et al. No for the second time. There has been no effort from the state of Idaho to set aside that amended non-dissemination order, nor has there been an effort from anyone else, including Mr. Kohberger, the defense, or any other intervening party to come in to the proceeding and ask the court, who has jurisdiction over this case, which is right now it's Judge Stephen J. Hippler, to set aside the non-dissemination order. So therefore, we're going to come back to that in just a second. What we're going to be talking about today, the reason why I set this up was to address final pretrial conference, facts, not the fairy tales. And if you go to, well, I should back up a little bit. Mr. Kohberger, January 30th of 2024, was extremely concerned about negative press against him and his constitutional right for a fair and impartial proceeding. That's a due process privileges that he has. When you see citations, 14th Amendment to the United States Constitution, that means you're entitled to 3 things. When a government is seeking to take your life, your liberty, your property away, it is, and one of them is to an impartial trier of fact. Here, the trier of fact is going to be the jury. He felt there was just so much negative press out there, it would be impossible to obtain a fair proceeding in Latah County, which is where this case should be presiding. The crimes occurred in Latah County. However, because Mr. Kohberger filed that motion for change of venue, there was a long battle over a period of multiple months. Latah County did not want that case to be moved. They fought against change of venue, I should say the state of Idaho. However, in September of 2024, the court, Judge John Judge, agreed and felt that venue should be changed. However, he didn't say where it should go to. He left that up to the Idaho Supreme Court. And the Idaho Supreme Court rendered a ruling, and you can find it on the docket, September of 2024. And they said it would go to Ada County, and they specifically appointed Judge Hippler. That's the confidence that they had in him to be the jurist over this extremely high-profile case with multiple issues that has captivated not just people in Idaho, but across the country and the world. Approximately 1 month after change of venue, we see the amended, this is the pretrial and trial order. It's dated October 9th, 2024. It is quite literally the blueprint for the case. You can see my copy here. I've got notes all over it. It's called the Redacted Order Governing Further Criminal Proceedings and Notice of Trial Setting. And what the court did is, by virtue of this order, he set the jury trial in this case to occur August 11, 2025, will run through November 7, 2025, inclusive of penalty phase if necessary. Now, what the court's referring to here is that if there is a return of not guilty to the 5 counts that Mr. Kohberger is facing by indictment, that's what he's facing at trial. And you can find the indictment that was rendered by Latah County Grand Jury, May 16, 2025. If there's a return of not guilty, case is over. Mr. Kohberger cannot be tried again under the double jeopardy provision of the Fifth Amendment to the United States Constitution. Trial ends, there's no penalty phase, everyone goes home. What he also did here was to submit all of the pretrial things that have to happen before trial. If you look through this document, you're going to see a lot of things that you're familiar with. Schedules for motions to strike the DP, all of which have been denied. The DP is on the table in the event of a penalty phase. The motions in limine, pretrial rulings on various, principally motions on evidence. What evidence should the trier of fact, which is the jury, be seen? What's going to come in, what's not going to come in. Most of them have been ruled upon. You're going to see motions you're going to see the schedule for witnesses. You're going to see when jury instructions were supposed to be filed, not under seal, ladies and gentlemen. The jury instructions in this order were not to be filed under seal. The parties decided to file them under seal. And Judge Hippler agreed that the jury instructions were to be filed under seal. Other things, witness lists, the lay witness list, the expert witness lists, the jury questionnaires proposed, everything's under seal in this case. That's what the court felt was appropriate. To have this case tried in a court of law, not in the media, not anywhere else, but in a court of law where only 12 people, their decision is what matters. And those are the 12 people who will be selected at voir dire. This order tells us voir dire is going to happen July 30th, 2025. That is 80 days from tomorrow. And even before then, the jury questionnaire is going to go out. On what date? We don't know. Because if you look at this first page of this pretrial and trial order, the only thing that's redacted is the date of when the jury questionnaires are going out. And so we're going to come back to this issue in just a second when we talk about what's happened this past week. I want to go to the section of the pretrial and the trial order, the last bulleted item. It says here, a final pretrial conference will be held on May 15th at 9:00 a.m. and continue on to May 16th if necessary. Earlier status conferences may be requested by the court and or initiated by the court. So what's that mean in English, common sense? That means this has the potential, this final pretrial conference is going to be happening this week, to be a 2-day event. There could have been other pretrial conferences that were scheduled by the court or at the request of the party. None have happened. This is it. As far as we know, the final pretrial conference in advance of the trial is happening May 15th and, if necessary, 16th, with the caveat being there is some type of a super secret hearing that is appearing on the case summary page that there's absolutely no notice of hearing attached to. It is on July 21st, 2025. There is a hearing at 9:00 a.m., 9 days before voir dire, before Judge Stephen J. Hippler. No topic. It's not addressed in this pretrial order at all. There's no order setting it. There's no notice of hearing. There's no request from either side. So we, the public, are in the dark as to what that hearing is for, as we have been for a very long time regarding many things about this case, which has been extremely perplexing to me. What typically could be discussed at a final pretrial conference? Why is it a big deal? Well, generally speaking, now we don't know what exactly is going to be discussed on the 15th and, if necessary, going into the 16th, with the exception of one item that we're going to get to in just a second. But usually what you see at the pretrial conference is the court's going to ask, Is there anything that's going to be happening like right now that I need to be aware of, or any plea negotiations going on that might obviate and we might not need a trial? If you guys come to me, you're going to come to me with some type of a plea deal that I need to sign off on. That might be something that's discussed at a final pretrial conference. Or on the other hand, it might be, is there anything in the world that could delay this trial from proceeding? And there's at least one that might. And that is the next issue that I wanted to address with you, which is the issue of alternative perpetrators. What's an alternative perpetrator? That's a defense. It's typically in all 50 of the states, and even in federal, when there's federal charges and a case is prosecuting in federal court criminal, the defendant may turn around and say, you got the wrong person. You got the wrong person. It wasn't me. It was this guy over here, that woman over here, or this group of people over here. So that's a defense. It's intended to raise reasonable doubt. Must interject that Mr. Kohberger, although charged with extremely serious charges in this capital case, at all times, he is considered not guilty under the eyes of the law until or unless he pleads guilty or is adjudicated guilty. And I, for one, am grateful that we live in a country where we have due process, as opposed to, I don't know, Iraq, China, Iran, where we don't, where they can just pull you in, you got no rights, they can impose whatever sentence, and that's it. Doesn't work that way in here in the United States. So I, for one, am thankful to the framers of the Constitution who had the brilliance to put in the Bill of Rights as demanded by the states who would not ratify that Constitution. Without the Bill of Rights, these protections, the right to remain silent, the right to an attorney if you're accused of a crime, First Amendment, freedom of speech, freedom of the press. These are all protections that we have heard about in this case up until now. I, for one, am thankful that we have these protections. Mr. Kohberger was facing, we had a bunch of in limine motions that were set by virtue of the October 9th, 2024 pretrial and trial order that set deadlines. Judge Hippler said, motions in limine, which is in limine pretrial motion application for a court order, are due X date. Responses, other side, due X date, replies, and then we had a hearing. The hearings on multiple motions in limine was back on April 9th. That was that long day of hearings where Judge Hippler went basically from 9 o'clock until I think after the courthouse was pretty much closed to get all of the motions in. One of them was a state motion regarding alternate perpetrators. And we have to go to the motion or the order, the court order, where there were multiple proclamations from the bench that the court made at hearing. What the court did is at hearing, he made some rulings. He had to memorialize them to writing later on. Some of the in limine motions, he didn't file an order until after the hearing. But I'm referring to this document, the April 16th, 2025 order memorializing multiple in limine motions. If you go to pages 5 and 6 of this document, this is what's going to be discussed at the final pretrial conference per Judge Hippler's order. This is relative to states MIL, motion in limine, right? Alternative perpetrator evidence. Sometimes you're going to hear it alternative, sometimes alternate. Same thing. It basically means you got the wrong person. Somebody else did this horrible, atrocious crime, not me. And what the court had said here is the state seeks an order prohibiting the defendant from offering, quote, alternate perpetrator evidence without first making a showing that such evidence is relevant and admissible. Okay. Evidence has got to be admissible and relevant. You got to pass muster under the relevancy rules. And then there's also the State versus Meister case that governs here, says it just can't be some wild theory. It can't be Mr. Kohberger coming in and saying, Oh, this guy over here looks shady over by the grub truck. Yeah, that's the alternative perpetrator. Or it's somebody that was hanging out in front of 1122. Looked a little shady to me. That's the alternate perpetrator. No, can't be mere inferences. Can't be I think. Can't be I believe. Can't be I suspect. Got to be with competent evidence. And that can be either direct evidence or it can be circumstantial evidence, one or the other. But he has been directed, if you go to page 6 of this order, to submit his offers of proof as to any alternative perpetrators by May 14th, 2024. I'm going to quote Judge Stephen J. Hippler right here. He says here, to avoid undue delay at trial, defendant must present the offer or offers. Judge Hippler's realizing that this may be more than one. Offers of proof no later than May 14th, 2025. Why? We continue on so that the matter can be addressed at the pretrial conference. And then there's an interesting footnote here. Footnote number 1. The scope of the preclusive event of this ruling, including suggesting that specific individuals looked at and cleared by law enforcement are alternate perpetrators without first complying with a showing required by this order. Judge Hippler, what do you mean? This means he's got to meet the rules of evidence and the standard under State versus Meister in order to properly come forward with these offers of proof of alternate perpetrator or perpetrators. And it's got to point to somebody, and it's got to point them in the direction of 1122 King and these crimes. And it can be even people who law enforcement's already cleared. So therefore, that is what is being submitted on the 14th of May, 2024 to be discussed at the final pretrial conference. Now, is this going to be a full-blown hearing? Probably not, because then offer of proof, then the state's got to respond. It'll probably be a hearing later, unless Judge Hippler makes a ruling and says, sorry, Kohberger, you haven't met the Meister standard. This doesn't, it's insufficient, and so forth. I know we've gotten some questions. I'm going to address them in just a moment. I want to go over the last thing on the agenda today, which is some of you might have been hearing me. I've got almost 650 episodes of the Indie Zone podcast, Idaho versus Kohberger. And I have probably submitted 12, 15 episodes with the title of Another Order Sealing Evidence. Another stipulation to seal evidence from the public. Here we have yet another order saying that evidence which should ordinarily appear on the open docket regarding what this case is all about. Note public, there's exceptions here. The state and the defense, sometimes via stipulation, went to the judge and said, we got to seal this evidence from public domain because to release it is going to lead to a disclosure of confidential police investigation techniques. And I'm paraphrasing. It could lead to privacy concerns. Someone's privacy could be divulged that should be protected. Whose privacy, how it could be, never explained. Here's my favorite, personally, that I've questioned many times. To disclose this documentation to the public, i.e. evidence, that's what discovery is, ladies and gentlemen, it's evidence, could lead to compromising someone's life or safety. And so you'll hear me a year ago questioning this, for example, saying, no, wait a minute here. The state of Idaho, you've only ever arrested one person for these crimes. And to my knowledge, Mr. Kohberger has been continuously arrested from December 30th, 2025. He doesn't get day passes, I don't believe, to be able to go out and effectuate revenge if he got mad and he learned some information here. So whose life and safety could be compromised if this documentation and this evidence is kept from the public? I've actually done at least 2 episodes a year ago asking those questions. If you look at the case summary page, and I invite you to, please, in any search engine that you choose, plug in Idaho cases of judicial interest. Case summary page was maintained by the clerk of court in Latah County initially. Then after change of venue, it was maintained by the Ada County clerk of court. And it lists all key events in the case. It memorializes hearings, all the filings, all court orders, the briefings. And when you hear that term, the briefings, motion, response, reply, that's the briefings. All the briefings, stipulations, affidavits, declarations, all of this. Trial orders, pretrial orders from the beginning of the case. I invite you to take a look at how many documents you see on the case summary page, and then you can back it up by looking at the court docket. If you see a document with a lock and key device on the case summary page, that tells you that that's a document that is under seal. Under seal from whom? From the public. Under seal from the public. It is, I've called it a virtual Mount Everest of information, documentation, evidence. Why? And I've questioned, why is so much of this case under seal? It really wasn't until 2025 when Judge Stephen J. Hippler came out and said, okay, stop filing so much under seal, but they still continue to file things under seal. Nonetheless, we started to get a peek at some of the evidence, right? First time we ever saw suspect vehicle 1, and these are still images, not video. Never been video of suspect vehicle 1 ever released to the public via the courts. We saw a couple of images that the defense submitted in one of their in limine briefings regarding what the jury should be able to see regarding suspect vehicle 1. The state filed their own stills in their reply in opposition to the defense's response. Remember, when you hear briefings, it's the originating motion by the party who's looking for the court order. Then you get the response in opposition, and you get the reply brief. And then Judge Hippler rules. Well, I've searched up and down the docket. I wanted to just, I've been up and down that docket so many times because I have to produce and do this podcast, and then also the content that I'm doing here on YouTube, which allows me to introduce some of the filings. I couldn't remember, even back into the investigatory period, there ever being releasing even 2 seconds of video of what is alleged to be suspect vehicle 1. And there have been multiple filings from members of the public, members of the media who have sought documents from the court files. They've all been told, no, you're not entitled to get these documents under seal. There was a filing last week. You know who Ashley Gillard is? She is a TikTok. They call her a psychic. I don't know if she's a psychic or not, but she had some interest in the case and she put out videos. She was sued by a professor at the University of Idaho because she came flat out and said that she believed that this professor had something to do with the crimes. That's at least what the court filings tell us. Well, that case has been proceeding in federal court. Oh, and you know who the professor's attorney is? Same attorney who represented the media coalition, who appeared before Judge Stephen J. Hippler in January, seeking to have one of the hearings that was scheduled for January 23rd at 9:00 a.m. Remember that hearing that was under seal? Media coalition wanted that hearing open, and they wanted the briefings on the IGG's information unsealed. Hippler said no to both. That's who's representing Professor in that case. Well, Ms. Gillard apparently filed a motion to get some documents that were under seal in this case. We've not seen the motion. All we know is that on May 7th, 2025, Judge Stephen J. Hippler has done what's been consistently done in this case. No, you filed an improper motion. It's stricken from the record, meaning we can't read what Ms. Gillard was looking for. And he directed her to go and file a public records request to try to get documents under seal out of this case. Now, we've known of a few people who have said that they've done the same. They've tried to get documents. In fact, a couple of them are on the docket. They've all been told no. No, this information's under seal. The prosecutor who has jurisdiction of this case says that information, evidence, discovery should be under seal, both in submitting that non-dissemination order and in every one of the supplemental responses to discovery, which tell us that discovery was produced, but we don't know what that discovery is because it's described in an exhibit. Same thing with the defense. Defense is just as guilty as wanting documents to be under seal, as far as I'm concerned, because Ms. Taylor drafted that first non-dissemination order, and she has filed requests for discovery describing what the evidence is in an exhibit that we're not entitled to see as the public. Mr. Thompson remains the chief prosecutor for this case, even though it's been moved to Ada County because these crimes happened in Ada County. In my opinion, if he wanted evidence to be opened, I think he would have moved to set aside that non-dissemination order, or moved to have all of this evidence that's been under seal. But what happened this past week? Does anyone remember? Same day that the order from Judge Stephen J. Hippler denying Ashley Gillard's motion, striking it as an improperly filed motion, seeking documents that are under seal in this case, was denied. It hit the docket May 8th. That same day, there were ads, public relations pieces that were coming out promoting a special event on this case. It was, I think, on the Today program or something. That's how early the Today program comes on, 8 o'clock, 9 o'clock on the East Coast, going to be 6 o'clock on the West Coast. And we start seeing video of suspect vehicle 1, images from the 8458 phone. How is this possible? I could not believe it. I said to myself, how is this possible that this information that has been withheld from the public for 2.5 years that no one could get has somehow now made it out? Who made that decision to override Judge Stephen J. Hippler, Judge John Judge, Judge Megan E. Marshall, and the parties? This special event aired Friday evening. I've had an opportunity just today to watch the thing from start to finish, and my jaw dropped, because there's a lot of, it's not just that it's, well, we believe that Mr. Kohberger, is probably guilty here. And not once did I hear the statement, Mr. Kohberger under our Constitution is considered not guilty until or unless he is adjudicated guilty in a court of law or he pleads guilty. Not one time did I ever hear that. But then I start to see images that's purportedly from the 8458 phone, and video and statements that we know what the prosecution is going to be charging Mr. what their evidence is going to be at trial when they bear the burden of proof at the beyond reasonable doubt evidentiary standard. I said, how is this possible? My biggest, right now, we don't know if Mr. Kohberger is completely innocent. We don't know if he was involved. We don't know if he was the sole perpetrator. We don't know if there's altered. We don't know, because we weren't there. But the bottom line, in my opinion, is that there's been a subversion, in my opinion, of the legal process here. This case was to be tried in Judge Stephen J. Hippler's courtroom in just under 3 months from now, with jury selection and jury questionnaires going out within the next 80 days. How does evidence under seal with an airtight non-dissemination order, when the public was told, no, you're not entitled to get this information, how does it get out to anybody? That's the question that I think we should all be asking ourselves right now. And one question that an overseas follower who was not able to be here today had indicated It's sent in. He's going to watch on repeat. Could this possibly lead to a mistrial or something short of that, some sort of ramifications to those? And we don't know who did it. This could have come from the state side. It could have come from the defense side, but it had to be someone with access to materials under seal. Could have easily been someone from the defense side. Could have been someone from the state side. It could have been a person that has a spouse, a significant other of someone who's involved that got access, sold it. We don't know. We don't know who's responsible. There's been no trial, so there can't be a mistrial. Could it possibly lead to another motion for change in venue? I don't know. But we've got to look at the fact that this trial was already moved one time because of negative pretrial publicity. And we are now less than 80 days away from the selection of the 12 people who will have this man's life in his hands. What timing? Should there be some ramifications? I think so. I truly believe that both of the parties should be filing motions about this right now. And the court should set some type of a hearing, because Judge Stephen J. Hippler needs to control this case. I fear we're going to have another OJ case again. Remember the last trial of the century, 1995, State of California versus Simpson? There was a lot of discussion that Judge Lancito lost control of that case. There's a lot of discussion that this is the case of the century, Idaho versus Kohberger. I think that Judge Hippler needs to do something about this, needs to find out why it is that for 2.5 years, the public has been denied access to documents through normal channels, told that information regarding this case needed to be preserved and introduced in a court of law to protect the state's interest, to protect the defendant's interest, and to protect the legal process. Does anyone have any questions? I'll get off my soapbox right now. Dateline clearly says obtained from LE. Maybe the gag order applies. I don't have a clue. Oh, hi, Sarah. I know that you've been on top of it. It had to come from somebody. Sarah, had to come from somebody who had access to the files. Does anyone here remember seeing? We've heard about it. How long have we been hearing about this? How long have we been hearing about this? The movements of suspect vehicle 1 speeding out of the neighborhood at a high rate of speed. Hearing from the 1112 camera, a thud, a dog barking, right? We've been hearing about this for a very long time. Those were 2 of the 3 things that led to Mr. Kohberger's arrest. This is not, as I've said, some video of him at Thanksgiving dinner 10 years ago or graduating from DeSales University. This goes to the heart of the state's case. So I caution everyone, don't, even though I understand that there's a statement out there that this came directly from law enforcement, that may not be the truth in the end. It could have easily come from the defense side. And then what we have, oh, well, let's bring in the media. And the media is going to say, well, we have a First Amendment privilege to protect our sources. So it might be difficult to get to the bottom and to figure out how this happened, but it did happen. And we are very close to trial right now. The timing is terrible. And oh, by the way, if you go on the internet and you search some of the Boise news media, the local media, you'll see some interviews with people that were involved in this special event. So it's being publicized in local media right where the jury pool is. Any other questions? If BK is found not guilty and walks free, can he sue? If so, who? MP? Well, you know, what surprises me is that the Guillard case is the only case for defamation so far we can be seeing a lot of cases for defamation. A lot of people's reputations have been dragged through the mud in this case. A lot of people, including, I mean, if Mr. Kohberger is found not guilty, possibility he would go out and sue for defamation. Oh my gosh, Miller Time, thank you. I'm so happy you're here. I'm so happy you're here, and thank you for your kind gesture. Miller Time's been a supporter of mine for a very long time. You know, I do this. I had a podcast for many years. It was on everything independent. Anything independent I'm into. Books, music, literature, people that have small mom and pop type shops. I'm all about it. I love that. And so I did have a podcast for several years that talked about things independent, including true crime. And I decided to transform it to a true crime podcast. And I had heard about the Kohberger case, the Idaho 4 case. And I said, if I'm going to follow this case, it's got to be exclusive. So I've exclusively followed this case. If you haven't had an opportunity to look at the podcast, if you're new to the case, if you want to do research, if you are an independent YouTuber, researcher, go in there, plug in the search terms. It will pull up the episodes. It'll tell you in 5 minutes or less what it's all about. I see Heather Fitzgerald's here. I know that she's done a lot. Go in there, plug it in. I don't want credit. I don't want anything. We want to get the truth out there. Use it to go onto the docket, and you can find the filings. What Dylan was doing on Instagram was speaking. Okay. Any media should be momentarily. Oh, hi. Gee Whiz is here. Any media should be monetarily penalized for information leaks. Well, unfortunately, there's a case called New York Times, and it's a Supreme Court case, and you have to have actual malice to go after the media for things like defamation. But media, let's face it, going to your question, which I think is excellent here, gee whiz, how the media get a hold of, they're saying it's actual evidence. They're not saying this is AI generated. They're not saying this is made up. And why would we ever question them for doing that? Did they break into the court's system to get it? No. Somebody who had access and who was under this non-dissemination order and knew full well that there's multiple motions that were granted sealing discovery, had to decide that they were going to be, in my opinion, that I give under the First Amendment, freedom of speech and of the press, had to decide that they were going to take matters in their own hands. They didn't like that this information was under seal and get it to start. It could have gone to 3 people before it ultimately got to, but we know it was valuable because nobody else had this. That's who needs to be held accountable, in my opinion, to the highest extent of the law, because the legal process here, in my opinion, as I give again, has been subverted, not by the media necessarily, but by the people who got that information, the evidence that's supposedly from the 8458 phone. How's that possible? How is that possible if Mr. Kohberger had the 8458 phone taken from him December 30th, 2022? It's 2.5 years ago. How's it possible somebody this past week gets images, searches, and then publicizes it and says that they know what a majority of the state of Idaho's case is? The trial briefs, which was what the state of Idaho's case was, and the defense's case was filed under seal. This pretrial and trial order didn't say the trial briefs were to be filed under seal. So how does the media find out what the state of Idaho's evidence is against Mr. Kohberger? Or most of it. I forget what the term was. Okay. Oh, thank you for your membership. I appreciate it. Thank you so much. Michael, you said an important word for this case. AI. Okay, Michael. Michael is coming up with an important point here. AI. I've wondered if an AI hallucination is what led LE to Brian Kohberger. It wouldn't be the first LE mess up with AI. I like it and I hate it, for some of the reasons that Mr. Clayton's bringing up right here. We'll make close to yeah, they're going to make a lot of money from that episode before it's all said and done. It's still not available for free. You got to pay. You got to be you have to pay to get that episode, ladies and gentlemen. As of today, it aired 2 days ago. Michael, thank you so much. Happy Mother's Day. Thank you. Thank you for being here. And I want to thank all of you for your support of the channel. When I started this podcast, Idaho versus Kohberger, it was in search of the truth, whatever way the truth led us. If it led us to Mr. Kohberger being the sole and the correct defendant, then in my opinion, the state of Idaho needs to throw the book at him. If it led us to he is a wrongfully accused person, then those lawsuits regarding what he's lost, what his parents, imagine a Mother's Day right now for the mothers of the 4 children. I call them children. They're younger than my children were, And what about Mrs. Kohberger? She's, from what we know, she loves her son. There was a statement that came out when it was family members in the courtroom. The Kohberger family, they support their son and their brother, which raises another issue. The order on family members in the courtroom has said that the Kohberger family can be in the courtroom during the entire trial, irrespective of if they're going to be called as witnesses for the state. Lady, you understand this is state of Idaho's calling them as witnesses against Mr. Kohberger in this DP case. Judge didn't rule and say, nope, you can't call them. Not at all. If they've got relevant evidence, the state has a right to call them, as tragic as it seems, but they have to be served. I don't know if you remember, back in 2023, do you remember there was supposed to be a preliminary hearing in this case where there would have been a mini trial, if it will. It's supposed to be the end of June to determine if there was enough evidence to bound Mr. Kohberger over to trial. Both sides agreed to a week-long trial, but what got that canceled was the indictment. Once the indictment came down, game was over, preliminary hearing done, then he was arraigned in open court. The charges, his rights read to him, remember, by not Judge Stephen J. Hippler. No, it was Judge John Judge, back in Latah County days. So there was an effort, and it was around May of 2023. One of the surviving roommates was no longer in Idaho. So defense could not serve her with a witness subpoena. They had to gain the cooperation of the state where she was, domesticate the state of Idaho, subpoena to have her appear at the preliminary hearing. There was a statement that Judge Megan E. Marshall wrote. There was a new file that was opened up because she was fighting coming back to Idaho. And then there was some discussion that she would speak with, offline. And then preliminary hearing got canceled. We don't know if that happened or not. Something like that's going to happen for the state to subpoena the Kohberger family, whether it's 2 of them, 3 of them, 4 of them, but they're described as witnesses, plural. So all eyes on Pennsylvania to see if something is opened in the Commonwealth of Pennsylvania, trial subpoenas to be domesticated to serve on the Kohberger family. Then they have to come to Idaho under contempt of court possibilities if they don't come and take the stand and testify. So that was one question that one of my viewers from the podcast who's overseas and is probably sleeping right now had written in. Oh, thank you, Rebecca. I appreciate it. And Capelli, thank you. Thank you. Yes, I am. Yes, I did go to law school. I'm retired and I teach. What I love to do is I love to teach. So in my retirement, I do some teaching a little bit on the side, but I really try these days to spend some time with my wonderful husband that I've been blessed with, my children, our dogs. We've got a great life. I can't be thankful enough. And I really am appreciative because I really enjoy doing this podcast. And I appreciate just your time. Your liking, your sharing means everything to me. because it helps us to grow and to get the word out. I'm going to be here through trial. You know, that's the commitment that I made to the children. I call them Xana, Ethan, Kaylee, and Maddie, in the search for the truth. But this trial needs to happen the right way. It's got to be waged in the courtroom where Mr. Kohberger's due process privileges are guaranteed, and he is cloaked with the presumption of innocence, which he is. He's cloaked with the presumption of innocence every step of the way. Now, I've had my opinions, you know, and it's fluctuated as I've seen evidence, but right now, after what happened this past week, my opinion doesn't really matter, but I'm going to give it to you. I don't know what's true and not true anymore in this case. I really don't. So hopefully we'll get some instruction from Judge Hippler. I think he is a jurist that, you know, is going to do something about this. I can't see him not doing anything. I think that one of the parties is going to file a motion, probably both of them. I wouldn't be surprised if Mr. Thompson and Ms. Taylor have no idea of what happened, how it got out, but that it did. And Judge Hippler may set a hearing. So I'm very curious if at the pretrial conference, the 15th and the 16th, if that will be addressed as well. And ladies and gentlemen, I think it's very important. If you possibly can sign into the final pretrial conference, it's critical, I think, because we are witnesses. We are who needs to make sure that what the framers of the Constitution and the original 13 states set this country up to be, that it continues, because even though it has flaws, it is, in my opinion, the greatest judicial system in the world. And we got a lot of problems, I know, but look at China and then get back to us later. We've got to show that we're interested. And you're clicking onto the final pretrial conference as being there, I think shows a lot. It shows interest in the case. It shows support for the victims, that this trial runs properly. And in order to, we don't know right now if this, I know Sarah has made some comments, I don't know if she's still here, that she believes that the final pretrial conference will be public. And so far as what we know from Judge Hippler's order, it is, but no guarantees. You might see something coming out this week that it will be partially closed, partially open, because remember, those offers of proof are going to be filed. And when they're filed, names are going to have to be named. So don't be surprised if you see something coming out this week saying that the final pretrial conference is partially closed. I hope it's entirely open all 2 days. But please, if you could go to any search engine of your choice, the Idaho cases of interest, it will bring up the website. You will see it is maintained by the Idaho Judicial Branch. That is the Idaho Supreme Court. You'll see multiple, usually high-profile cases of interest. One of them is the Kohberger case. You will see watch hearings live. You click on that button, it will take you to another area for the 4th Judicial District. And they know how many people are signed on. And if they see 2 or 3 people signed on, nobody cares about this case. If they see 2,000 people signed on, that's a bigger thing. Now, I know some people have said, they've written, Kathleen, you keep saying, go to the, I can't, I'm blocked. I'm blocked here in Japan or wherever, in Scotland. If that's not possible, I think that somebody on YouTube, at least a few of them, will be hosting live. Please show your support there. It's important that the courts know and that both sides know, and the name of the victims and in the name of our judicial system, that we stay involved in this case. Are there any other questions? Do attorneys employ non-attorneys to do research? Lil Montana, non-profit. Yeah, Lil Montana, yes. Attorneys will have, Judge Hippler has a staff attorney on his team. He's got a judicial assistant. He's got a legal assistant. He's got a staff attorney. He has referred to her a couple of times, who does legal research for him. He's going to check and see if what the sides are saying when they're filing a motion, an application for a court order, that he's not making reversible error. So what attorneys do, yes, they'll have paralegals, they'll have staff. You might hire someone who's a law student to come in and do legal research for you, but they're bound. And as the attorney, you are responsible. If they go out and they go remember the Kobe Bryant accident, that helicopter accident, where someone snapped some photographs of the accident scene and actually showed it to friends? Sometimes that happens. They share and share and share, but it is the people who are bound. The attorneys, bottom line, have responsibility. Okay, any other questions? Always a need to work her alter. Yes, supporting proof, arrest affidavit, lies, will in-house. Well, a good point. Sorry, if an arrest affidavit was all lies, they tried in the motions to suppress to get the warrants thrown out, and they were all, the Frank's motion, all denied by the court. And I've done a couple of presentations. Judge Hippler made the right ruling, I believe. I think the state, in my opinion, that I give under the First Amendment, the United States Constitution, I think the defense made an error in not raising standing in one of their motions to suppress. You got to raise standing. You got to show that you have a reason to want this IGG evidence thrown out, because maybe, it was a crazy thought, but hey, my distant relative, if they consented to a 23andMe test, that's my chromosomes too, my DNA. I didn't sign off on it. Need to have standing. The court has ruled on all of the motions to suppress, which sought to throw out the warrants, the Frank's motion, all of that's been denied by Judge Hippler. That's for appeal at this point. I'll say offline until the hearings. Yes. Hello. New here. Hi, Amber. Happy. Thank you for joining us. Please stay aboard. Hope you'll look at our videos. You'll be here. We'll be here through trial. If I remember, Hippler will have law students sitting in. Yes, Miller time. I believe at the last hearing where Twizzlestick, I believe the Twizzlestick is in the room here. You were at that last hearing, the marathon day of hearing, when Judge Hippler, there were some law students that were in the courtroom that day. That may have been, I don't know if sometimes the professor may assign them to go watch a trial. And if you're attending law school anywhere near Boise, you're going to want to attend this trial. But there have been other trials where the judges are law professors. They'll teach, they'll be adjunct professors, and they'll have their case, the suitcase case, I forget, I'm drawing a blank, down in Florida, where the woman was brought up, that she had, her significant other was in a suitcase and he suffocated. The judge of that case was a law professor, and some of his students came in and actually watched the proceedings. So a really great point, Miller time. Any other question? Susie 66. No, I don't think Judge Hippler's biased. I really don't. I think that I've agreed with most of his rulings, including on a couple of them. No, I think he's not. I mean, he came out hard on the state in a couple of rulings, including on one of the in limine motions here in this multiple order ruling, where he gave the defense, hey, what they're raising here, even though you didn't raise it, I'm concerned about relevance. Hint, hint. When you bring this up at trial, you might want to object on the grounds of relevance. Sustained. Move on. Next question. Hippler's not a trailblazer. I've been lurking, but wanted to say, hey, hi, Christy. I'm so happy that you're here. Glad you're here. You did a lot of comments early on. Glad you're back. Okay, let's Twizzle. I don't think they were in law school yet. Oh, you don't think they were in law school yet? Maybe undergrads, Twiz. Sarah Boone. Thank you, Juliana. I'm having a mental block here. I couldn't remember the Sarah Boone case. The judge in that case, he taught, I think it's the University of Central Florida, or the University, one of the law schools in Central Florida, because of course that was in Orlando, and several of his students, he took a picture with one of the students published it and thanked him for giving the could you imagine learning about criminal procedure from the judge, and now the judge is on a high profile case, and you're in there and you're able to see the process of voir dire. Now that's another question that I have to ask myself. I think Twiz had indicated he was going to be going to voir dire. Is that correct? In July 30th, voir dire. That is the process of jury selection. They will be seeking a death qualified jury. In other words, they're going to be asked Can you, will you, if you're able to, when the sentencing phase, sentence the ultimate penalty here? Some people, they'll say, religion, no, can't do it. My religion says no, I never will. Then they're going to probably be stricken from the jury. But jury selection will happen July 30th. And who knows how long it's going to go on. Will this be a 3-month trial? Well, guess what? State of California versus O.J. Simpson, the trial of the last century, was supposed to be 3 months. It went on for 8-9 months. There's no guarantee this trial is going to be 3 months. It could go on longer. You just don't know. Sometimes, even if you're doing what's called a deposition, you may think, oh, it's going to be 10 minutes I need with this witness, blah, blah, blah. Then all of a sudden, the witness drops a bombshell, and you now got to ask 20 follow-up questions. And then the other side has got to get in, clean up. That's just how it is. You just don't know what happens at trials. But he's predicting it's going to be a 3-month trial, and that voir dire will start July 30th. Right now, according to the pretrial and trial order, it says voir dire will be open, and there is a Supreme Court case that says in only very, very, very slim, narrow, and it's got to be a compelling reason, voir dire needs to be open, because it's important for the public to be there and to witness voir dire. The process of, they brought on, the state of Idaho did a smart move. They brought on a new assistant attorney general that all she does is she specializes in jury selection. They may have jury consultants working with them to try to pick. So much is at stake here in this case. And a lot of it, that jury, Judge Hippler, in terms of guilt, his opinion doesn't matter. My opinion doesn't matter. No one's opinion except those 12 people that will be in the box. That's who matters. They're the trier of fact. They're going to decide how much weight to give to a witness, to believe a witness, to not believe a witness. Guilt, innocence, that's the ultimate decision. Any other questions? Hi, Amy. Glad to see you here. Mark, fire. Okay, Mark, fire. Hopefully that's not toward me. Mark Stewart is saying firing squad. That's right. With this case, I won't be surprised if it goes. Christy, I agree with you. I wouldn't be surprised if voir dire goes beyond August 11th. Who's to say they're going to be able to seat a jury that quickly? Keep that possibility open, ladies and gentlemen. Amy saying, hello, agree, Jason. Purcell, the judge is playing a fair game, but I don't like his facts. Okay, I think Taylor should have proceedings at Chuck E. Cheese. He might get a better chance. Theodore Baker. Any other questions, ladies and gentlemen? Because it is Mother's Day, I want to spend a little bit of time with my wonderful husband and children, but we will definitely be back with more content for you. I've got a couple of things that I will be dropping this week. And of course, I will be watching that docket for you. And as things happen, you'll be the first to know. You will absolutely 5-minute or less episodes. Check out the Idaho versus Kohberger podcast if you haven't already. 5 minutes or less. It will tell you where to go on the docket if you want to do research on anything. Indictment, discovery, seal. If you want to hear me complain about, another motion to seal discovery, another order to sell. I'm telling you, I probably 12 times. I despise this gag order. I think it has done so much. I think maybe it had good intentions, but it has done more harm than good. But still, it's in place and it needs to be respected, and things need to happen the right way. Not this, this idea that, we're just going to go and engage in self-help and do what we want. Okay, lady. Oh, I'm so glad, gee whiz, you did, Jason. To everybody, I want to thank you all for being here today. Please, if you haven't already, subscribe to the channel. If you're interested, be a member. We're going to do some member-only content as we get closer to trial, and definitely check out the Idaho versus Kohberger podcast. If you'd rather do it on Apple or anywhere else where it is iHeart, but I really, really strongly recommend here on YouTube because it's got that search engine for you, and that docket is really getting big and it's complicated. So if there's no other questions, thank you. Thanks, Amy. I'm so happy you all came in today. You took time out of your Sunday to be here. We'll be doing a couple more before trial. This is only the second one that I've done. I don't try to do too many lives just when there's something important. And it just so happened. I scheduled this about a month and a half ago. And then we had what happened this past week. So Thank you all very much, and we'll see you again soon. Bye, everybody.